Okay, Mr. Graff, you're up.
Good afternoon, Your Honor. Thank you, and may it please the court. My name is Andrew Graff. I represent Synergy Contracting Group, Incorporated, as assignee of the clerks in this matter. And the issue that we're here on today, Your Honors, is a grant of what was essentially a cross motion for summary judgment in favor of defendant, granting final summary judgment, and a denial of a motion for some final summary judgment and a motion for attorney's fees pursuant to section 627, 428 that plaintiff pursued in the underlying action, or a petitioner, excuse me. This is a petitioner for writ of certiorari. The action initially went to the appellate panel of the circuit court. A decision was rendered per curiam affirmance during that time period. The recent statute that was passed, which transferred jurisdiction from the circuit court to the district courts for direct appeals from county court cases, was passed. And so while the time period for a petition to be filed was pending, this court issued a mandate. There's been an argument, and I'm sure there will be arguments when FedNet has its turn to argue that that mandate somehow nullified or canceled or prevented a petition for writ of certiorari from being pursued. I don't believe any case law was presented that supported that position.
Well, I will, though. The scenario that happened does raise some concerns, Mr. Graff. That is not the concern that I have. What does cause me some concern is that effectively the decision of arguably the decision that was issued by the circuit court appellate panel became our decision. We became the court in the case, and we issued the mandate in the case. So I do have a little concern about, and believe me, this is a conundrum that has probably happened in a lot of situations because the legislature said every case goes, not any case filed after such and such a date. So it creates this issue. Might you have filed a motion for rehearing in the case?
Your Honor, I have not found any case law that directs anything on this kind of situation. So I can't tell you definitively the case law says this is how it should have been gone about.
If there had been a motion for rehearing filed within 15 days of December 23rd, I think is when the circuit PCA was filed. If there had been a motion for rehearing filed within 15 days, either in the circuit court or after January 1 in this court, we would have been in a position to decide that, correct?
If it was properly brought, yes, Your Honor. I mean, of course, if there was the time limit is admittedly 15 days for a motion for rehearing, yes.
Right. So if it had been filed, say, on December 24th, it would have come to us before the response time on January 1. If it had been filed after January 1, it would have been in our court regardless. But that motion for rehearing would have been pending at some point, and we could have examined the correctness of the circuit court decision really under a regular appellate standard of review at that time, correct?
I'm going to apologize and say that I wasn't fully ready to brief that.
Oh, I understand this, but it's kind of red flags flying.
Sure.
Because you're asking us to issue a writ of certiorari to engage in a second tier review of what is in effect our own, legally our own decision.
That could be the way to look at it, Your Honor. I don't have any case law to point to that says that if the case is transferred after final disposition to a higher court, that de facto turns it into a decision of the higher court, and therefore you have to pursue a motion for rehearing as opposed to pursuing a second tier tertiary or certiorari review.
Well, we issued a writ of certiorari. The writ of certiorari would be directed to the circuit court, which actually no longer has any jurisdiction.
Well, it would have jurisdiction if you entered a writ of certiorari down to the county court, the circuit
county court. Okay. All right.
And directed the circuit county court to apply the correct law, which of course I will hopefully get to.
Okay, go ahead. I'll shut up now.
Well, I'll say this: the point is taken. It's a novel situation. I believe the steps were taken that we thought was appropriate under the circumstances.
Yeah.
With respect to the substance of the claim. Or of the petition. This is a water loss that was remediated by my client, and there was rebuild services rendered by my client pursuant to an assignment of benefits. Specifically, I won't go too much into the timelines because I'm well aware that the court's read through the briefs and has rough ideas of the timelines. But generally, in May of 2016, the loss was discovered, and by June, my client was involved with providing repair and remediation services. On June 22nd, my client provided its rebuild estimate and its emergency services estimate, and requested payment of those items. The emergency services estimate was eventually paid in full. That really isn't the subject of this petition, so I won't spend much time on it, but the rebuild estimate was for $9,857.58. After that June 22nd date, there were a series of attempts by Synergy to collect payment for its estimates from FedNet, the defendant, or the respondent. Specifically, June 28th, Synergy called and asked for a status on payment and a request for payment. July 29th, another call requesting status of payment and payment.
And would you clarify, you did get to an appraisal and there was an appraisal award and
correct.
And was that was the spread there was from around 3,000 something to how much?
The spread there was $8,900 worth of approximately, a little bit higher, but
beyond what had been paid.
No, $8,900 that was left unpaid from the final rebuild estimate, and $8,000 of it was found to be compensable under the appraisal award.
Well, that's what I'm asking. So there was an appraisal award, and it was in addition to what had already been paid.
Correct, Your Honor.
Approximately 8,000 something beyond what had been paid before.
Correct. There was a $500 deductible that was pulled from that to decrease the amount to $7,500 that was paid, but $8,000 of the $8,900 unpaid was found to be compensable. So money was owed. There was an incorrect underpayment of benefits in this case. The reason I started to go through, and I like I said, it seems like we're going to skip past it. The reason I started to go through all those interactions, those communications, is central to this issue is whether once this payment was made, the case law in Florida is clear that is a confession of judgment, absent some sort of rush to the courthouse defense that it is that is proven to the court, that the insured was somehow unaware of the dispute and the insurer didn't have it within its power to resolve the dispute prior to a suit being filed. And that's just simply isn't the case here. There were months of communications that, once again, I won't go through in detail, but requests for estimates to be amended by Synergy from FedNat, a refusal to do so, and standing on the estimate and requesting full payment of that estimate. That was done not only over the phone and through email, it was also done through a person-to-person meeting in March of 2017, coming up on a year after the adjustment process. And FedNat stood on its $3,500 initial payment on the rebuild and never paid an additional cent. Didn't ask for additional documentation, didn't say we need more from you before we were able to consider this and pay it. Nothing. Eventually, February 5th of 2018, a final demand is sent. And with that final demand, the exact estimate that was initially sent for rebuild was provided, with the exception that there was one line item added to that rebuild estimate. And the line item was for approximately $2,600, and it was supervisory hours. In response to that demand, FedNat 3 weeks, and the demand requested payment or some sort of communication within 10 days. 21 days later, FedNat responded saying, one of the estimates, the contents estimate that you've attached to this demand, has been paid in full. If you have any questions, give us a call. That's it. No further communications. And 63 days after the demand was sent, Synergy filed suit. As the court pointed out, appraisal occurred. Not only did Synergy recover well in excess of the difference in payments from the initial estimate, but also recovered the majority of the revised estimate, the final revised estimate that was submitted on February 5th. Once that was done, the litigation that we're here on today began in earnest. There was disputes over how to resolve it. It was plaintiffs or petitioners' position that it needed to be done either through summary judgment, because there was facts the court had to look at to determine whether there was a rush to the courthouse or not. And if it couldn't be resolved through summary judgment, through a short trial, as there were facts that needed to be found. And it was defendant's position that this was a post-judgment motion for attorney's fees that could be resolved in just a normal post-judgment attorney fee hearing, and that no facts were necessary, or if there were, that the court could just resolve them on its own. I believe the case law that we represented in our brief makes clear that in situations of 627, 428, in fact, it's in the statute itself, attorney's fees are part and parcel of the claim and need to be resolved at the same time and not after judgment. And that makes sense because you only get attorney's fees or entitlement to attorney's fees under 627, 428 if the payment of the appraisal award acted as a confession of judgment. So the confession of judgment issue necessarily has to be resolved prior to entering judgment for either party. The court ultimately, I don't think really took a position one way or the other, but said, here's what we're going to do. We're going to have a hearing, a summary judgment hearing. If you want it, this is the date you're going to have. Get your motions filed by the appropriate time and we'll have a hearing. So that's what happened, at least so far as petitioner is concerned. Petitioner filed its motion for summary judgment, an amended motion for attorney's fees and costs 20 days before the hearing. 5 days before the hearing, defendant filed its response, or what it called its response, and its cross motion to dismiss with prejudice. While it was titled that way, it was not a cross motion to dismiss. It wasn't arguing within the four corners of the pleadings. It wasn't saying that based on the pleadings, this is a cause of action that's no longer viable or wasn't viable in the first place. Instead, it attaches summary judgment evidence and makes argument based off of that summary judgment evidence that it was the prevailing party in the lawsuit, or that it received a judgment of no liability because the breach of contract action was somehow mooted by its invocation of appraisal. So to me, clearly based on
if I get it right, that's the judgment. That's the argument that the judge bought.
Yes, and the issue is that the judge didn't apply the right law in buying that argument. So the law is the rush to the courthouse that I think this court's probably well aware of. It's heard of it before. That if the insurer was aware of the dispute, had the power to resolve it, and failed to do so, the payment of the appraisal is confession of judgment. That's what was argued. Beverly, Hill, Clifton, Goff, all decisions that this court's well aware of because it's second district decisions. And in response, the defendant argued that section 627, 70131 subsection 5, which is a statute that is titled Insurer's Duty to Acknowledge Communications Regarding Claims and Investigation. It has nothing to do with whether there's an accrual of a cause of action or not. Subsection 5 of that says that within 90 days of insurer receiving notice of an initial, reopened, or supplemental property insurance claim from a policyholder, the insurer shall pay or deny such claim. And if they fail to do so, that they owe interest. And so the argument goes, even though nothing in there states that that there's any preconditions for suit there, that this is a breach of contract statute for policies, and that you have to give them 90 days before a breach of contract action can accrue. The argument was that without even saying it, that's what that statute was doing. The issue, of course, is that Castro, once again, another decision from this court, says the exact opposite. Castro goes through and talks about a situation where there was a sinkhole loss, and 4 years afterwards, additional information after denial was sent. And the insurance company in that case decided that this acted as new information. And so it's now a reopened claim. It's a supplemental claim. Please submit yourself to an EUO. Please do all these things that really are supposed to be a part of the initial adjustment of the claim. And we'll take it from there. The insureds refused to. They filed suit, and this district went through and said, no, there's no requirement because of 627-70151 or 131, that subsection 5, that because you've submitted additional information and in an attempt to try to get this worked out without a suit, that somehow that restarts the clock or nullifies your previous decisions. And so that case law was provided to the court, and that's what the court found, or the court did not find the Castro case persuasive. The court found persuasive the argument that 90 days was granted as a result of the updated estimate with the one line item of supervision hours added. Of course, there was no discussion, there was no explanation about how that nullified the vast underpayment of the initial bill, which once again, clearly FedNat stood on that denial or that refusal to pay any additional funds as months and months and months passed after Synergy attempted many times to get full payment for that initial bill and never received it. No explanation from the court was given why the new estimate at the end cured that failure to pay the full amount of that bill, or any amount above $3,500. The one piece of summary judgment evidence that the court relied on in finding that this was a reopened claim or a supplemental claim for the purpose of the statute was that the adjuster for FedNat in her deposition testified that this was treated as a reopened claim by FedNat when they received the demand. The issue is that's a conclusory statement with no facts to support it when Mr. Felsey, who was the attorney handling the matter at the trial level, cross-examined that. The corporate representative admitted that she didn't know whether the claim had been closed, whether the claim was reopened. She was simply stating that it was her belief that because there was a letter sent in response to the demand letter from FedNat to Synergy saying that we've already paid one of your invoices, that somehow that showed that there was a reopened claim. And then Mr. Felsey repeatedly asked a variety of questions that if the court would like, we can go through to drill down into, okay, tell me what actions you took, tell me what steps you took to adjust the claim once you reopened it. Mr. Hall either would not allow those questions to be answered by the corporate representative, or the corporate representative simply stated she didn't know or that nothing happened. So none of the behavior of the insurance company that was actually allowed to be inquired into reflects that any steps were taken by the insurance company to treat this as a reopened claim or to take any steps to pay it after there had been over a year and a half, coming up on 2 years of a dispute, a well-known dispute between petitioner and respondent regarding the amount of benefits that were due and how much should be paid for the rebuild.
And Mr. Graff, you didn't mention whether you wanted to reserve some rebuttal time. And I think you're getting, I can't say this precisely because I used up some of your early minutes, but you're getting close to 15, I think. So,
so I will reserve 5 minutes, Your Honor. So okay. I'll quickly close by saying, essentially the court, they're certainly for the purpose of the petition of certiorari, the court misapplied the law, the relevant law, in determining whether or not there was a rush to the courthouse by applying the statute as opposed to this court's case law and the legal status of whether you were forced to file a claim to get the insurance company to pay what it owed, and instead substituted this statute, and that the court relied on that to the detriment of petitioner. Also the due process of petitioner was violated because respondent was allowed to engage in a motion for summary judgment without complying with 1.510, as it did not file its motion or summary judgment evidence in support of that motion 20 days beforehand. And I'll save the rest of my time for rebuttal.
Okay. Thank you, Mr. Graff. Mr. Hall, you're up.
Thank you. Good afternoon. May it please the court. Kenneth Hall on behalf of the respondent, FedNat Insurance Company. And Your Honors, this appeal and this case, which at bottom represents petitioner's continued attempt to extract attorney fees out of the insurance company.
Well, Mr. Hall, they sued, essentially under the confession of judgment rule, it seems like they would have been entitled to fees if you didn't otherwise meet, some sort of obligation to show that it was a rush to the courthouse, et cetera, to prove some exception.
Well,
right?
Your Honor,
they sued, you invoked appraisal, they got an appraisal that exceeded what you had paid by around $8,000, and you paid it. And then you say, well, now what? It's moot. And then, I'm confused about what the theory was presented to the trial court. But
well, sure, Judge.
It seems to me that's a perfectly legitimate effort to collect attorney's fees.
Well, it's actually not, Judge. And the theory, just briefly, because as I'll get to later in the argument, we really shouldn't even be discussing the theory of what was presented to the trial court in this proceeding, because we're here on second tier certiorari.
I understand that, but let's come back though, because let's assume, for instance, the trial that and this presents another certiorari kind of difficulty, but I don't think you can say this is just yet some sort of improper attempt to collect attorney's fees when it seems to me that the underlying action was perfectly legitimate.
Well, I would disagree with that, Your Honor, in that the underlying action was perfectly legitimate. And the theory, the basic theory that was presented to the trial court stems from the Hill versus State Farm case, which is Judge Altenburn's opinion from this court from 2010, in which he clearly says that there is a requirement that claims adjustment break down. In other words, that there is an impasse reached between the parties where a lawsuit is the only remedy left to force payment. And the facts of this case,
and you're saying the trial court on summary judgment decided that's not what happened?
Yes, Judge. And
how could that happen without taking evidence? How could that happen without an evidentiary hearing?
The trial court did take evidence in the form of the
not in a summary judgment case. You don't take evidence in summary judgment case. There is record evidence that the judge looks at. You can't make fact determinations based on that. You have to have unrebutted facts.
Yes, Your Honor, and there were unrebutted facts, and that's sort of a distinction that was lost on petitioner at the trial court, which was presented to Judge Kelly, is that the transcripts of the respective corporate representative depositions were synchronized. They were in complete agreement with regard to the underlying facts of the claim. The only thing,
that's on one side of the case. They were in complete synchronized agreement.
No, Judge, on both sides of the case, there was no he said, she said, or a disagreement about when something was submitted or about when.
So theoretically, then the appellate court, that being, the circuit court and then us, would have been able to look at that and say, okay, that on its face entitled you to judgment as a matter of law.
No, Judge, and there was no judgment as a matter of law entered in FedNet's favor. It was simply a denial of Synergy's motion.
There was a judgment as a matter of, there's a judgment in it that says plaintiff shall take nothing by this action. Yeah, your side obtained a judgment. Okay.
Well, Your Honor, the important point, and I think we're sort of missing the big picture here in this discussion, is that this appeal is an apple with no bites left, and the court should deny the petition for certiorari, which is what we're here on today. That's the procedural vehicle that petitioner has used, is a second tier certiorari review.
I understand.
Yes. So the petition should be denied for three reasons, and Your Honor already addressed the first one, but second tier certiorari jurisdiction is simply not available because this court already had direct jurisdiction to review this case when it was transferred from the circuit court. So
could we treat the petition for certiorari as a late filed motion for rehearing?
I don't think so, Judge. I don't think that there's any case law or any provision in the appellate rules that allows for a petition like that to be filed, months and months and months after this court has already issued its mandate. I mean, and that's my next point.
Actually, that's not what happened. The petition was filed on the day the mandate was issued, not months and months later.
In terms of months and months after the original per curiam affirmance was entered, and I think that's what Your Honor was getting
at. A month after. That was a month after, not months and months.
Sure, Judge. But the point
roughly 2 weeks late.
Yes, Judge. But the court had jurisdiction. It issued its mandate. It relinquished jurisdiction back to the trial court. And so this court has already had a direct opportunity to review the merits of this case when it had this case. The second reason that the petition should be denied is that if this court were to consider this case again, it would have to do it by exercising second-tier certiorari jurisdiction. And petitioner cannot meet that very narrow standard that's required for that to apply. And this is the critical distinction and what that petitioner just overlooked in its entire opening argument here in terms of rehashing the argument that was made to the trial court. The standard for second-tier certiorari jurisdiction is not a failure of the trial court to apply the correct law or a failure of the trial court to afford due process. It's a failure of the circuit court sitting in its appellate capacity to do those things. So the case.
I understand that too. You got to, now let's assume for the sake of argument, we decide that the trial court applied the incorrect law. Are we in a position, even though the circuit court didn't write an opinion, to examine the briefs filed in that case to determine whether the PCA issued by the circuit court was a misapplication of the correct law or applied the incorrect law or not?
No, Judge, because the case law says that the relief that petitioner is asking for, which is essentially what you just stated, to go back to the trial court and undo what the trial court did, to reverse that original trial court order, that is simply not an option that this court has if it exercises second-tier certiorari jurisdiction. The case law says that the appellate court has no power in exercising its jurisdiction in certiorari to enter a judgment on the merits of the controversy. And so the only relief available if this court were to entertain second-tier certiorari jurisdiction would be to quash the circuit court's PCA and send it back to the circuit court to apply the correct law. So the relief.
And then what would happen then in terms of our jurisdictional conundrum, do you think?
I don't think there is a jurisdictional conundrum here, Judge. I think that do
you think that just totally eliminated second-tier cert when the case was transferred to us?
I do think that's the case, Judge. And I know that it's a quirk of the way that the legislative change was made, and it's a little bit unusual, but that quirk did not deprive petitioner of any fundamental due process. And so to get back to the timeline that Your Honor mentioned at the very beginning here, the circuit court entered its per curiam affirmance on December 23rd, 2020. This case was transferred to this court on January 1st, 2021. It was assigned its own appeal. It had a case number 2D210143. At that point, this court had direct jurisdiction over the appeal. At that point, petitioner could have availed itself of any of the post-opinion appellate motions that are available per the rules. So in other words, if petitioner wanted this court to review this case, it should have asked back then. Options available, it could have done a motion for rehearing, a motion for written opinion, which would have been a salient thing to do since this was a per curiam affirmance without a written opinion, a motion for rehearing en banc. If any of those options were addressed at that point, this court could have taken them up and addressed the substance of the circuit court PCA and when it had direct jurisdiction. But petitioner filed no such motions relating to that ruling. And then over a month passed until, as Your Honor noted already, the mandate was issued on January 22nd, 2021. And looking at the language of the mandate, it says, quote, this cause having been transferred to this court and after due consideration of the opinion issued. So, petitioner says that this statement doesn't mean that the circuit court PCA was imputed to this court or that this court adopted it, and that nothing in the mandate supports that argument. But my question is, what else does after due consideration of the opinion issued mean? Petitioner says that's just pro forma. Due consideration must not mean that the court actually reviewed the record, reviewed the PCA. I guess we'd have to ask Chief Judge Kuzama about that, since she's the one that signed that mandate. But to me, it says consideration of the opinion issued means that the PCA was imputed. There's no reason to allow this appeal again when it was already considered. And what we're essentially talking about here, Your Honors, is sort of an appellate res judicata situation. It doesn't happen very often, but this is a matter decided. Petitioner missed its opportunity for additional appellate review And the insurance company here should not be strung along in perpetuity, defending appeal after appeal after appeal. And so to move on to the substance really of what we're here talking about today is the standard for second tier certiorari jurisdiction. Again, nothing having to do with the merits of the trial court argument, as petitioner spent so much time on and in the brief as well. But there's case law and there's narrow standards for exercising second tier certiorari jurisdiction. And what emerges from the case law is that it's not supposed to be an opportunity for a second appeal. That's exactly what's happening here. It's not an opportunity to re-argue the merits of the underlying dispute. And that's exactly what petitioner has done and spent roughly 30 pages of the petition doing. The key question for second tier certiorari review is whether the circuit court in its appellate capacity denied procedural due process or committed some sort of fundamental error or applied the wrong law. And that comes directly from the 2012 Florida Supreme Court Nader case. And so what we're really supposed to be doing right now is looking at the mechanics of the circuit court appeal, not a look all the way back at the trial court decision as petitioner would urge. So in looking at the mechanics of the circuit court appeal, is there any suggestion that the circuit court sitting in its appellate capacity denied procedural due process? In petitioner's response on page 6, petitioner points to its brief and says, we have alleged procedural due process. But again, that's all an argument about an alleged denial of due process by the trial court, complaining about what the trial court did or what the trial court did not do. That's not the standard. We're not supposed to be looking at that. So what could some examples of the circuit court denying due process look like? Well, irregularities in the briefing schedule, maybe not granting extensions when asked for, not allowing opportunities to supplement the record, outright denying the appeal without an opportunity to be heard. None of that happened here. Both parties had equal opportunity to supplement the record, fully research the positions. The briefing went on in the summer and fall of 2020. Extensions were duly granted. There was no problems complained of with regard to what the circuit court did. Both sides had a full and ample opportunity to argue their positions. And then the 3-judge panel from Pinellas County made a ruling and reached that decision in December of 2020. There has been no procedural due process failure alleged by petitioner with regard to the circuit court, and there simply was none. So that prong cannot be met for second tier certiorari jurisdiction. The second question is, did the appellate court apply the wrong law? Again, petitioner says in its response, yeah, we addressed this in our petition, but again, that's an allegation of an incorrect application of the law by the trial court, not the appellate court. And that's what we just heard in petitioner's opening, is complaints about what the trial court did or did not do. But that's not the standard for second tier certiorari jurisdiction. And in fact, because this was a per curiam affirmance by the circuit court, there's actually no way to tell what law was applied by the circuit court. And so
you're saying that back in the day when circuit courts were appellate courts, and assuming procedural due process was honored, an appellate court could never grant a petition for writ of certiorari on second tier cert from a PCA.
From a PCA, if the PCA stood alone by itself, I think that's a true statement. And I think that's—
Which is why I asked, could we examine the briefs to see what was argued to the circuit court sitting in its appellate capacity?
Well, I think that in order to answer the question as to whether or not the circuit court applied the wrong law, you would need to know why the circuit court reached the PCA. And because it was a PCA, I mean, that's sort of the circular problem that we're in here, is that—
So you're back to, well, it's impossible then for us to grant a petition for writ of certiorari.
I think that's correct. I think that's correct. There's actually no way to tell what law was applied by the circuit court. There's no way to make that judgment as to what law the circuit court in its appellate capacity applied, or whether it was applied incorrectly or not, because it was a PCA. Now, again, that points to the fact that petitioner could have asked for an explanation. There's nothing that prevented petitioner from filing a motion for written opinion, which is provided for in the rules, a motion for rehearing en banc, to suss out what it was that the circuit court analyzed in reaching its PCA. But as the record sits here today, during this proceeding, there was no motion like that filed. And so we've got no actual way to tell what laws applied. And another point on the fact that there was no opinion here, but rather a PCA, this goes further to assuage the worries of the courts that have granted second-tier certiorari jurisdiction, where the circuit court does write an opinion, but makes some sort of fundamental error. And so the third DCA in the Geico court said, this could be a problem if we have a circuit court issuing an appellate opinion that makes a fundamental error, because now we're going to have other parties, waving this opinion around and compounding the error by having that be precedential authority for all the other county courts. That, again, doesn't happen here. There's no danger of compounding any alleged error, even though there was none, because there's no precedential effect from the PCA. So even though Judge Kelly's original ruling was 100% correct, as affirmed by the 3-judge panel of the Pinellas County Circuit Court, if there was any error, it was in no way a grave miscarriage of justice, which is another prong that must be met for second-tier certiorari jurisdiction to apply. It's in no way a grave miscarriage of justice for this AOB corporation to have to pay its own attorneys for this one case, instead of shifting that burden to the insurance company like it's attempted to do in literally hundreds of other cases that it has prosecuted. So, Your Honor, the conclusion here, just sort of bringing us back to what this proceeding is all about. It's about second-tier certiorari jurisdiction, if the court even goes that far to re-accept jurisdiction of a case where it's already issued a mandate. And theoretically, the trial court could be marching along on its merry way right now, because it's been mandated to take actions that put the mandate of this court into effect. So we've sort of paused those proceedings to allow this to conclude, but there's nothing stopping the trial court from having that mandate in hand going forward and entering all sorts of other rulings. But I just wanted to.
You see, if again, playing devil's advocate, assuming that we were to conclude that the trial court was incorrect to begin with, and that this PCA was incorrect, could you see why what you just said would be a cause for concern, that the trial court is merely going along applying this incorrect ruling? Why we might be a little concerned about that?
I could see how that's a problem, Judge, but the assumptions that you've asked me to make, one of those assumptions is prohibited by the case law, which is having this court today dip back down into the trial court to address the merits of what the trial court
but
did.
you see, now we are the appellate court over the trial court.
You're the appellate court over the circuit court in its appellate capacity, and that's.
But we are also the appellate court over the county court.
Only through this second-tier certiorari.
Or maybe for purposes of going forward, right? So if any rulings that come thereafter we think might be incorrect, we might then address them under the straight appellate standard of review, correct?
I think that would be the case, Your Honor. But the point is that today is not supposed to be a rehash and a re-examination of trial court issues. The case law is clear that this court has no power in exercising second-tier certiorari jurisdiction to look at the merits of the underlying controversy. It's only supposed to be focused on what the circuit court in its appellate capacity did. And I'll conclude by referencing the Nader case again, which is the Supreme Court case that governs this procedure. And it says, quote, appellate courts must exercise caution not to expand certiorari jurisdiction to review the correctness of the circuit court's decision, because it would deprive litigants of the finality of judgments reviewed by the circuit court and ignore societal interests in ending litigation within a reasonable length of time and eliminating the amount of judicial labors involved in multiple appeals. Your Honor, this litigation needs an endpoint, and the time has long come for this case to be over. So because this court has already had this case in a direct jurisdiction fashion and has issued a mandate, because petitioner has not and cannot allege the requirements for second-tier certiorari jurisdiction, which again is a focus on the circuit court's process, not the trial court, this court should deny the petition for certiorari. Thank you.
Thank you, Mr. Hall. Okay, Mr. Graff. 5 minutes.
Thank you, Your Honor. I appreciate the time. First and foremost, I'll start with the argument that petitioner has only paid attention to the circuit trial level, not the circuit appellate level, and that is fatal to any attempt to secure certiorari review. As the court rightfully pointed out, what that means is that in any situation where there's a PCA, this court has no power to step in and exert any kind of remedial authority over a circuit appellate court's decision. That seems to be unsupported, I would say. I'm not aware of any cases that state that outright. Of course, once again, this is a very unique case in terms of its procedural
Are there any
posture
cases
and
in
how.
which secondary cert has been granted when the circuit appellate ruling was a PCA?
Your Honor, I'm so sorry. I've got a landscaping crew outside of my house, and I had a hard time hearing you.
Oh, are there? You said that you didn't find that proposition of law in any cases anywhere, but did you find any cases in which second-tier cert was granted to quash a PCA?
Quite honestly, Your Honor, I didn't look. That wasn't the focus of my brief, and it certainly was more of a tangential issue from the answer. I spent the majority of my time focused on the petition. If the court would invite or would like a supplemental brief on that, I'd be happy to provide it. I will say that one of the avenues that I think Judge Northcutt was exploring with opposing counsel is the idea of, is there any possibility for the appellate court to treat this petition as a motion for rehearing or some other applicable or allowable motion, post a decision motion, given the fact that there's a possibility that the PCA becomes basically a decision of this court as a creature of that statute from the legislature transferring jurisdiction. I'm generally aware of a number of appellate cases talk about how the form of filings on appeal should be ignored in favor of fairness, and that the court should look at the substance of what was trying to be achieved and whether that was achieved. Once again, this is a very unique situation. I've never seen this situation before, so I don't have.
I will point out one of the problems with my proposed theory was that you're well out of the rehearing time, and actually it was filed the day of our mandate issued.
Correct, and I'm not entirely sure which came first, either the mandate or the petition.
Yeah, I haven't looked at the timestamps, but
sure. So I understand that there's an issue with that, Your Honor. I as I said before, if the court would like further briefing on that, I'd be glad of the opportunity. I just don't have that answer for the court today. With respect to the argument that this is a 100% right case and correct case, there wasn't much time devoted to that, I think, because there's not a whole lot of strength to the decision that the circuit court made. And in fact, the circuit court opined in a recent hearing that it thinks it might have made the wrong decision. And the reason I bring that up is it goes to this miscarriage of justice. While the county court is acknowledging that it thinks it might have made the wrong decision, it's standing on that decision, and it's actually granted entitlement to fees to respondent now, based off of a PFS that respondent has sent out, offering a nominal amount of attorney's fees to dismiss the case once the appraisal has gone forward. So not only, counsel tries to depict this as the only bad result of this is that in one case, possibly appropriate fees pursuant to 627-428 won't be received by petitioner. And that's simply not true. It goes further than that. In a case where a suit was filed, further benefits were secured, respondent is now seeking and getting the county court to agree that its fees are due to it as a result of its PFS. So
has the court issued that order?
Yes, the court has issued that order.
And is it within 30 days of that order?
No, Your Honor, it's well past. But I would posit that is not a final order until the resolution of the amount of fees is.
Oh, yeah, I get that. All right.
Yeah, the amount hasn't been. It's just the entitlement. The lower court
has not awarded fees at this point.
Found entitlement to fees based off of the PFS, and then was generally aware that we were seeking further review of the PCA and has put a pause on any further proceedings while we're working this out, Your Honor.
And there's a motion for fees by the insurance company on the same basis before us. Okay.
Yes, the insurance company is seeking to get its fees paid for invoking appraisal post suit, paying the appraisal, and saying that it won. So that's
one because there was a zero judgment. That's the language of the offer of settlement or offer of judgment statute, correct?
Correct. It won because there was a judgment of no liability. Once again, on the what petitioner asserts vigorously is an incorrect application of law using a statute that has nothing to do with the breach of contract action.
Okay. Your time is up, Mr. Graff, so you need to stop. Thank you both very much. In order to leave our courtroom, you need to click the leave button in the lower right-hand corner of your Zoom screen.